Hi guys, so I would like to talk about life, what's happening right now. So I currently have a lot of DVRO cases, like I mentioned, and clients send me a list of questions that to me, the answers are obvious, but not to them. So I'm going to just read them and respond here. What is the difference between a hearing we planned for domestic violence versus a trial? So first of all, at a hearing, it's a 20-minute hearing, meaning the judge hopefully read the pleading and the responsive papers, and usually it will be 30 people in the room, and it's really tough to put a client on a stand and describe everything that happened to determine credibility, which is what the hearing is about. Is what the other side is saying true? Is what we're saying is true? In order to determine that, we need to have so I do depositions before, and then we put the client on the stand, tell their story. So no, the hearing is not enough to tell your story, and that's what the trial is for. Trial is for where there's nobody usually in the room other than although it's a public proceeding, so other than us and the other side, and the witnesses are outside, and then we put the client on the stand and the client testifies, and the judge determines at the end of the trial, which can be 3 hours, could be longer, the credibility. What is the expected outcome of the trial? As a lawyer, I have a hard time saying what an expected outcome would be without going into the deposition and depose the other side. How can I tell? When a client tells me a story, I believe my client usually, unless it's obviously then it's obvious not. Then I tell my client, look, your story doesn't sound credible. I had those cases and clients complained, but I tell them, I rather tell you the truth from me than you hear it from the judge. So, or you need more evidence. In order for me to determine what the likely outcome is going to be, first of all, I don't have a glass ball, but to estimate I have to be in the judge's perspective. And the way I put myself in the perspective of a judge is when I literally hear from both parties the same story. So I can hear it from my client because our conversation is confidential and the client hired me. But in order to hear it from the other side, I depose them, meaning I invite them to my Zoom office. Usually before COVID, it used to be in my office. Now it's in Zoom. They come with the opposing counsel. The counsel objects, it doesn't matter, but I still get the answers. I still get to hear the answers because nobody can rule on their objections. And the client answers my question. It's a testimony as if we were in the courthouse under penalty of perjury. We have a transcriber, we have a court reporter typing it all up, and then we have a transcript after this. And after I hear from their, from their perspective what happened, what I hear from my client's perspective, I can gauge who I think is more credible. And sometimes the deposition is designed to ask more questions and to actually hear and put the other side in a position where they sometimes contradict themselves. And that's when I know they're not credible. So I want to ask if we... Okay, this is not a good question to respond. I really need to understand what is the civil restraining order and what is the criminal restraining order. Okay, so there are 3 types of restraining orders. One, it's called emergency protective order, which is given usually when someone calls the police, and it's called EPO. It's given for 5 days, and then there is a hearing in criminal court, and the judge might give it for longer. So that's separate from what I'm doing. In our world, there is so-called domestic violence restraining order. It includes, oh my gosh, it includes so much. It includes stay away, it includes custody, it can include attorney's fees, spousal support, child support, property restraint, move out, releasing of weapons. I mean, if you look at the form DV100, it's a lot. And in that, we first have a hearing, and then potentially deposition, and then a trial. And this is so-called CLETS, meaning it's going to be registered. CLETS, I don't want to I can Google it, but if you Google CLETS, it's telecommunication. Basically, it's registered, and police can access it. So if the difference between civil, CLETS is criminal, quasi-criminal, although it's in family court, because it's enforceable. If someone violates it, a victim can call the police and the violator will be arrested. And civil restraining order, it's a contract. It's not an order. So the judge doesn't sign it, because the judge is only allowed to issue domestic violence restraining order. Civil stay away order, it's not an order, it's a contract that is enforceable. So if someone violates it, you cannot call police to enforce it. It will be a civil violation where if someone violates, I would have to go to the court, seek damages, attorney's fees. Not the same easy tools, I would say, to enforce it. Civil stay away would be used in cases where someone, for example, is filing domestic violence restraining order in order to get advantage in custody dispute, and then realizes they can get custody orders without it, meaning sole custody, little visitation to the other party, and then they're like, why do I have to go through deposition and trial if I can drop my restraining order and agree on custody orders I want to begin with? Or if both parties have a child and they don't want to fight in court and they want to stay friends, then they agree on a mutual stay away order. Okay, so I'm going to keep it short. So this is it for today. If you have any questions, ask me down in the comment section below. Bye.